Okay, good evening to everyone. Thank you so much for being here. I want to first start off by reminding you to please mute your audio and turn your video off. And I want to thank all of those people that are here from the bar. We see quite a few people here from the bar. We hope we also have people from the general public here because we are so excited to start this series that will be a monthly series, Family Matters with Judge Phil Smith. And I want to go ahead and present Judge Smith at this point, and I want him to tell us about his vision and this series that he has come up with. Hi, Judge.
Well, hey, Steph, thank you. Thank you all for coming out on this dreary, cold, snowy, icy night. First of all, I know most everybody here, there's some names I don't recognize, but what I want to do is to really kind of educate or inform the community about what we all do up in Fourth Circuit Court. It's one of the family law courts, and y'all know we have a heavy caseload and we address a lot of issues. The lawyers know this, but we need to educate the public as to what family law courts do in Davidson County. And that's what the goal is to kind of promote knowledge of the communities. And I would ask all the lawyers that are on, next time invite your clients on. I think that would be really good to kind of, listen to the discussion that we will be having. And tonight is just a general overview. And for most everybody on here, it is going to be like going back to your first year of family law in law school. It's simplified and intended to educate the public. So we're going to be talking about a lot of things, and one thing that I want to really stress is how important family court is. You all know, most of you that's been there know, we cover a lot of areas. We deal with a lot of important issues. Most importantly, obviously, is children. We want by the month-to-month presentation, we will go into more detail on specific topics. But tonight, just an overview of what family law court does. And, we're going to touch on some issues. We'll answer some questions. And please do not hesitate to chime in with a question.
Yes, absolutely. If you have a question, please feel free to put it in the chat. Please understand that because we are doing this for more general educational purposes for the public, we're going to be answering questions in a very general sense. So please be mindful of the questions that you post. And if for some reason we don't get to your question because we run out of time, or it is a little more specific than what we're intended to do at this point, we apologize. Certainly, you always have the ability to contact Fourth Circuit Court. If you've got specific questions, you can contact me. We're here to help, but we definitely want this series to be something that is very useful for the public in general, and getting to be a little bit more informed about family law and family law courts. So, but before we get there, Judge, let's talk a little bit about, we all know Phil Smith as the judge, or many people here do. They're used to seeing you in court and used to seeing you on the bench. But let's talk a little bit about Phil Smith, the person. So,
Okay. All right.
So earlier today, you said that, Pam, your wife, you mentioned that Pam's gonna kind of keep Prissy out of the room or out of the way as you filmed this tonight. So who's Prissy? Tell us about Prissy.
Well, Prissy is my 14-year-old, going on 15-year-old Shih Tzu. And she is the one that really keeps me young when the grandkids are not around. We love her. She's got the run of the house. She is spoiled rotten and gets her way. Just a family member. And and we love her, but if she's back here, she's going to chime in with her opinion. And while y'all may not understand, I think I will understand what she's saying.
Yeah, I think you understand when she gets a little upset sometimes. You've talked about something that she does when she's not very pleased with things.
Yes, she will relieve herself on the spot.
On the spot, right in front of you.
Right in front of me. Yep.
And so how do you handle that as a pet parent?
Oh, wow. We have got a carpet cleaner. So, we use it quite often. I don't spank her. Wow, how could I spank the sweet little girl? But I do get aggravated with her.
Yeah.
It doesn't happen a lot, but it does happen.
You mentioned the grandkids. So tell us a little bit about the grands.
Yep. I've got actually three grandchildren. One is a teenager. He's got a girlfriend. He's all about that. And then I've got a 4-year-old granddaughter, Hadley. She's a ginger. And 2-year-old, soon to be 2-year-old grandson.
And what do they call you?
They call me Pawpaw. And they know that they can come to Pawpaw and get whatever they want within reason. Pawpaw will spoil them. Yeah, I loaded them up with sugar this weekend, and when Kelsey and Mikey, my son-in-law, came to get them, they were sugared up for the day. So
great. So how were your holidays?
Great. Little going stir crazy right now, but ready to get back to work and get some of these cases knocked out. And as we all know, we're going to be opening back up on March the 15th in person for a lot of things. I'm going to keep the schedule, I think, that we've continued to do, and only in-person hearings will be final hearings on Tuesday, or contested cases on Tuesday and Wednesday, and contempts on Thursday. And modification hearings also.
So let's talk a little bit about this week. We've had some unique circumstances come up this week. Hope everybody has been safe and their home safe. And at this point, the courts have been closed since Monday. Obviously, Monday was a holiday. What do you expect for the remainder of the week? And I know that you don't know for certain, but what are you planning for?
Well, we know tomorrow is closed. I do think that if we get the weather that's being predicted, we're going to probably be closed on Friday. I hate that because that's motion docket, but my initial thought is that we just have 2 motion dockets next Friday and get through them, and plan to stay late and get caught up.
So let's talk a little bit about, I know that for tonight's purposes, you really wanted to do a general overview of family law. And before we get into that, I want to ask you, why do you find that family law is so important? Why did you, what inspired you to want to do this series that you'll be doing over the course of months? And why do you find that family law is such an important area that people need to be aware of and educated on?
Well, it's pretty simple. When you ask a group of people, if what their experience with the judicial system is, have you or a close family member hired a lawyer for a civil or personal injury case? Field will say, yeah, maybe. Have you hired you or a close member of your family hire someone for a criminal case? They'll kind of chime in and say the same thing. But then if you ask them, how many, or has anyone, you or anyone in your close family hired a family law attorney, most everybody will raise their hand, because at one time or another, their family members or themselves have had experience in family law court. As lawyers, what the family law courts do, but the public at large really doesn't understand family court. And we really have 3 family courts in Nashville, 2 in circuit court, and of course juvenile court. And we cover a lot of ground, and I'm only going to talk about circuit court tonight, but, circuit court, we have a lot of responsibilities. We try the divorce cases, both pro se, uncontested, and contested cases. We cover the dependent neglect appeals from juvenile court, particularly those that are associated with the divorce case. I will tell you, the other circuit judges at this point are picking up some of those dependent neglect cases that are not involved in divorce cases and taking those. We cover all the post-divorce matters, enforcement of orders, child support, visitation, custody, modifications of child support, custody, visitation, alimony, enforcement, this modification of alimony. All of these things we do. We handle adoptions. In fact, Fourth Circuit handles all of the adoptions in Davidson County unless there's a conflict. And then it will generally go to Judge Robinson if he doesn't have a conflict in the case. We handle the orders of protection at the circuit court level. Of course, many of y'all have been in front of Special Master Ballinger. Judge Robinson and I get those appeals. We have habeas corpus jurisdiction on custody cases. There's a lot of different things that we do, and the public just doesn't really understand the extent of what family law court does. And that's my goal, is to educate the public so they will have some understanding of what the family law courts do.
Yeah, I think that when you came to me with that idea, I thought it was amazing. I'm hopeful that the attorneys that have joined us tonight find it to be informative and reach out to their clients for future episodes to tune in. We are going to have this posted on a YouTube page so that people can go back and look at these episodes. And so it could be very educational for clients, litigants, pro se litigants, as you talked about, and things of that nature. So I want to ask you, 9/11 was one of the things that transformed and changed air travel as we knew it then and now know it today. I remember being able to go to the airport, and whether you had a ticket or not, you could go all the way to the gate and sit there with whoever may be traveling until that plane took off, and you could watch it take off and, just kind of leave the airport. And of course, nowadays we're unable to do that. If you don't have a ticket, you don't get past security, and screening at security is a lot different. And so, that event changed the way we travel. Clearly we've had COVID, and it has impacted, I have to believe, every area of business that exists. And it has changed the way that we do business and society as a whole. And I guess the question for you would be, what do you see in the future as it relates to changes that may be a little more permanent in the court system as a result of COVID, if anything at all?
Well, I think you're going to continue to see health measures being taken by courts. In the summertime when we don't have COVID, you don't have a lot of illness and stuff, but we've run through several flu seasons. And I think this has taught us that we can take precautions in the courthouse to prevent illnesses such as the flu or a flu epidemic, as the case may be. Those healthcare measures will probably be somewhat permanent at different times of the year. And for any lawyers that have been in Fourth Circuit, you can see the precautions we've taken with the plexiglass around the podium, the plexiglass on the witness stand between me and the witness, as well as the social distancing. I do think the social distancing will probably change. We may use it during flu season, things of that nature. I think the technology is probably in a lot of areas here to stay. How it is going to look after COVID, that's still up in the air. Quite frankly, I really haven't thought about it. That's something I will be thinking about in the future. But use of more uses of bridge lines, maybe Zoom for certain types of things. All of these things, we need to look at. Entry into the courthouse, health scanning of lawyers and litigants coming into the courthouse. At different times of the year, we may go to that. But there will be some permanent changes that have resulted from this pandemic. And it will be in an effort to prevent, people from getting ill at the courthouse. Courthouse is a place where people gather, most of the time not by choice. But we've got to protect these folks and keep them safe, and make sure that when they come into the courthouse, there's not a huge fear of contaminating them with COVID or the flu or whatever.
And you mentioned the courthouse as a place where people gather. And I know it's been your concern a lot during this period of COVID that lawyers have been able to see each other in the ways that they would normally see each other, like on the Friday motion docket, maybe catch somebody they've been trying to get in contact with to talk about something, or just have communion and fellowship. Even our hug and love sessions on Friday mornings. Talk a little bit about that and how beneficial that is for the bar, and how those good relations are beneficial for litigants. Because I remember as a lawyer, litigants would sometimes be a little leery if I was too friendly with opposing counsel. They felt like that was a bad thing. Where I would always have to explain to my client, you want me to get along with the other side because we have to work together. So talk a little bit about what the importance of, good camaraderie with the lawyers and how that trickles down to the benefit of their clients.
Well, first of all, let me say, I think in Davidson County, the camaraderie of the Nashville bar is exceeded by no other genre of practice. The lawyers in the domestic bar that practice the family law cases, most everyone gets along. They like each other. I know that Cynthia Green Campbell started the domestic relations Facebook page. I think that's been great. I know that Carla Miller had started the gatherings that we would have down in the Gulch and various places on Fridays, and then more recently on Thursdays. I can't wait for that to continue. Those were fun. But camaraderie and collegiality, more importantly, are really important in the bar. And I see some folks here on the screen: Grant Glassford, Joyce Sims. I saw Marlene earlier. Marlene's there. These are lawyers that were around when I started practicing. They remember the open door policy that Fourth Circuit Court had back then. The old Fourth Circuit Court used to be where Chancellor Perkins has his courtroom now. But collegiality was really established back then in Judge Muriel Robinson's policy. You can come into the ante room, get a cup of coffee, don't be too loud, but you can sit out there and talk and discuss your cases. That was really where hug and love came from. We need to do that more when we get through COVID. Obviously, COVID has prevented lawyers from having a in-person relationship, but those relationships are so important. And when you pick up the phone and call a lawyer and discuss your motion or what may be going in your life that prevents you from being there, it is a real benefit when you have that confidence in the other side that you can pick up the phone, talk to the other lawyer about the case, and you're ultimately saving your client money by being able to do that. Having a relationship with the other lawyer is that is so important. so important. Cases are going to come and go, but lawyers are going to be around for 30, 40, 50 years. We just lost one this week in Bobby Jackson that had been around for 50 years. So collegiality is so very important.
Yeah, I think it's important for litigants to truly understand that, because I believe people sometimes feel like because they're fighting their spouse or their ex or whatever, that their lawyers should be fighting as well. And that does not necessarily inure to their benefit in the long run. As you mentioned, it can be a lot simpler and less time consuming and expensive to pick up the phone and make a quick call versus having to do things in a more formal manner. So I think that's good information for people to understand. Let's switch gears a little bit and talk about how the accommodations that the court makes for litigants. We did get a question in advance tonight, and somebody wanted to know, how does the court deal with diversity? In particular, they're asking about language barriers. There was a question about, can the court have hearings where there may be a litigant that is deaf? Like, what accommodations are available to litigants in the courts to assist them?
Well, actually, there's a lot, and you know, it's I remember when we were first closed down, there was a lawyer that was hearing impaired, and we sent a letter to Chief Justice Bivens to have that heard in person, and we were granted permission to hear it. She was very good at reading lips, but she didn't feel comfortable doing it over a Zoom presentation. So, but no, we have interpreters that'll come in and sign for folks. It will be more difficult from a Zoom standpoint. We've got language interpreters. Christina Frazier, who many of y'all know, does an excellent job in setting up those interpreters for the courts. And we're using interpreters more and more every day. But if you have a client or you are a litigant and you have the need for an interpreter, whether it be signing, language, then please notify us. We will do everything we can to get an interpreter there. Now, there's certain languages where there are fewer interpreters, and we may have to adjust the schedule and maybe not hear it on the day that they have set to be heard. But we will do everything we can to work to ensure that their due process rights are protected.
So what has the court experienced, or are we seeing more cases, or at least recognizing more cases where we're seeing mental illness with our litigants? And what type of resources are available in those cases? How does the court handle?
Yeah, I mean, we are seeing more mental health issues in domestic cases, and it can range from, one parent having a mental health issue to, minor children having mental health issues. What the cause of that is, I don't know. I do believe that the opioid epidemic has had an effect on that. And the question is, in any particular cases, if you treat the problem of addiction, do you do away with the mental illness? Those we have to look at those on a case by case basis. But as far as the resources are concerned, certainly we have the mental health cooperative that will work with litigants to provide appropriate treatment. We've got people that can do drug and alcohol assessments, maybe even some mental health testing. In order to address the problem, we need to know what the problem is, and that is a difficult issue, and that we deal with in divorce cases. But I will tell you, I did the Middle Tennessee mental health docket last week, and it's the mental health issues that we deal with there, as well as in domestic cases, seem to be getting worse. And those are things that, one, we have learn, particularly in the domestic violence area, how to deal with those. And, I hope the legislature will address the statute and allow us to provide mental health relief or treatment for some of these people that are on the, the DV dockets. I think that's key. But particularly in that area, we've got to, as well as parenting areas, we've got to address those problems.
What's the best way for an issue if a lawyer has a concern about a litigant's mental health status? What's the best way for them to present that to you in court, or how should that be something that is presented to the court?
There's no good way to do it. What I do is if a lawyer can bring it to my attention in open court, and that's certainly, I understand lawyers got to be very diplomatic in that area, but if they can bring the concern to me in open court, that their client may not be able to assist them in the preparation of a defense or preparation of a trial, then I'm going to appoint a guardian ad litem to basically determine, do they have the ability to assist their counsel in getting the case ready for trial? And I've had cases come back both ways. I've had a couple of guardian ad litem reports say, yeah, they're fine. They've got an issue here, but this is not, doesn't rise to the level where they can't assist their counsel. And I've had cases where it has come back and they have issues. And so at that point, what I do is generally give the guardian ad litem the authority to pursue a conservatorship case down in probate if one is warranted. Or if that lawyer doesn't want to do it, then, I would ask the guardian ad litem to advise the family that this and the lawyer representing the party that this needs to take place. Once a conservatorship is filed and granted, Judge Kennedy assumes jurisdiction over the divorce case. This is an agreement he and I and Judge Robinson worked out, 8 years ago, I guess. And what it does is give Judge Kennedy the ability to consider the needs of the non-conservatorship spouse when dividing property and establishing support and things of that nature. He's got everything under the umbrella, and it works a lot better for him to be able to deal with those issues. But if you can bring it, to me and let me know, we will appoint a guardian ad litem to determine that issue.
And you did mention earlier that we do see cases where addictions are involved. Opioids can be an issue. Opioids. I'm gonna get it right. Opioids could be an issue, as well as alcoholism and prescription drugs and illegal drugs. How do you treat that in your court? I know that you have talked about, you have a personal experience with a family member that has had an alcoholism issue.
Yes.
And so when you see these matters in court, in particular, when we're dealing with parenting issues, how do you treat parents that are struggling with addiction in your courtroom? Because that can be a very scary thing. Obviously, you're balancing protecting the children, but are you also looking to give the parent an opportunity to address their issues so that they can be involved in their children's lives in a meaningful way?
Yeah, I never like to give up on a parent. In fact, we get a lot of cases where temporary restraining orders are requested, and drugs and alcohol use by a parent are the reasons for the request for emergency relief. I've had it go both ways. I've had parents that just can't beat the problem. But at the same time, I do know that you just can't give up on everybody and just say, yeah, you got to deal with it yourself. What I have been doing of late is keeping, a tight leash on those cases. I want to review those cases every 60 days, 45, 60, 90 days. I want to know where they are, what the status of their addiction or abuse is, and keep an eye on it, because if they are, go through a treatment program, if their problem calls for it, and they're in AA, and they're really focused on their problem and not relapsing, then I want to get them back to where they need to be, and that's parenting their children. Children need two parents, and they need to deal with their problems and understand they're going to have to deal with those problems before they can be a really good parent. But I'm not going to give up on them unless I just absolutely, they just don't get it. I'm not going to give up on them. We're going to work towards reuniting them with the children. Now, there again, it may not be, they may have lost custody or primary residential status, but it's the relationship that we want to preserve. That's really, really important. And that's children need that. And that's what my goal is. So I know lawyers get aggravated with me, particularly when I set it for review 45 days out, 60 days out, or 90 days out. And it does cost their clients money. And for that, I'm sorry. At the same time, as I have said many times in court, my ultimate obligation is to the children, and I take that seriously.
And is it helpful if somebody maybe is a UT supporter or family? If they drop that little nugget, does that help?
No. Everybody knows I'm a big UT fan, although it's a little difficult right now. Unless they're a member of the University of Florida, a current or former member of the University of Florida coaching staff, I would probably have to recuse on the coaching staff, but everybody else I'm going to be fair to.
So I want to go back a little bit to just the overview of family law that we really wanted to get into tonight, and just kind of go through the areas. As you said earlier, as we do episodes each month, which will be the third Wednesday of the month from 6 to 7 p.m., you will get more in depth into various aspects of family law. But you really wanted to go through just a couple of big picture items. And so let's start with divorce. Let's talk a little bit about contested versus uncontested. I think that's a big thing that litigants usually don't have a good understanding of.
Yeah, uncontested divorces are probably about 90% of the divorces that we grant in Davidson County. And, I would like to say they're simple. They're not simple. An uncontested divorce involves the parties agreeing to every issue that arises out of that divorce. Children, if there's children, there's got to be a parenting plan, a division of property, child support, alimony. All of these issues have to be agreed to and encompassed in the appropriate documents. A lot of people don't understand that, you can settle your case in a way that you might not be completely happy with, but it's something you can live with. And I'll be honest, in my opinion, that's the best way to go. And a contested case is just a case that, less than all of the issues have been agreed to. In many contested cases, none of the issues have been agreed to. And at that point, the court's got to decide the issue of grounds, division of property, primary residential status, and alternate residential status if there are minor children involved, child support, decision-making authority, potentially alimony, attorney's fees. all of these things are argued by the lawyers and proof submitted to the court so that the court can decide all of those issues where the parties really have no say. I will tell you one big thing, and I want to talk about next month on divorces, are pro se divorces. And we're seeing more and more pro se divorces now than we have since the pro se divorce program started under Access to Justice. These are people that don't have the ability to hire a lawyer and usually don't really have any assets. And these are the cases that they're going to come through, they're going to reach an agreement because there's really nothing to argue over. And we're going to get them on out of there. In all divorces, in all divorces, there's a 60-day waiting period from the date of filing until the court has jurisdiction to grant the divorce if there are no children. It's 90 days if there is children. You know, we need to be cognizant of the fact that, you know, a lot of these people really want to get out of the relationship, and it's really a safety factor for them to get out of the relationship. Maybe there's domestic violence, but uncontested divorces, whether pro se, non-pro se, are really the best way to do a divorce. And, you know, it's certainly less costly. But if you go in with the mindset you're going to be reasonable in settling your case, then there's a good possibility the case will settle. If you go in and say, no, I want my spouse's head on a platter, case is probably not going to settle. And we have to remember that there are those cases. We're in an emotional area. Domestic cases, divorce cases, all of these cases we handle with perhaps the exception of uncontested adoptions can be very emotionally, even on uncontested divorces.
Yeah. And I think it's important for people to understand that a divorce is contested until it's not. So when a divorce is filed, until there's an agreement that everyone has signed off on, it is considered a contested case. And once there is a settlement, then it is uncontested, and you can proceed on an uncontested basis. We have a question about pro se divorces, and I want to kind of capture it from a little bit more general standpoint, but we got a question. Do you think that the number of pro se divorces is increasing during COVID? I know you have an opinion on what you think the number of divorces will be post-COVID, generally speaking. Will you talk a little bit about that?
Yeah, I think we're going to see an explosion of divorce filings after we get through COVID. Now, I'll be honest, I don't believe there's going to be one day and, you know, we go in and say COVID's over with. But I think you're going to see an explosion of filings when we start reaching that, herd immunity. When we start reaching that, you know, and it's, if you look at holidays, you know, Christmas time, Thanksgiving, summer vacation, if you look at those kind of in a microcosm, you see that a lot more filings a significantly higher number come out after those periods of time. People decide spouses decide they don't like each other. And when they spend all of that time together, they just don't want to be married anymore. Post-COVID, you're going to see employment a lot better. You're going to see probably both parties going back to work, and they're not going to be, kept away from crowds. They're going to be out, going to be able to, see their friends. They're going to be able to go out in public, be able to go out to a restaurant free of fear from being contaminated or infected with COVID. And I think that once the economy comes back, we get where we're approaching herd immunity, I think you're going to see an explosion of divorce cases. My personal belief, No empirical data to back that up, but I do believe that's going to happen.
That people are just spending too much time together, right?
Oh yeah, yeah.
My theory was always, you're right. There would always be an explosion, for lack of better words, of divorces after holidays. But I would say holidays are the times when people outside of the marriage that a spouse may be engaged in a relationship with, that's when that really kind of comes to light. When somebody didn't show up for Christmas dinner, or you see discharge for this gift, and but absolutely, we do find that those periods do seem to show up a little bit more in the courts. So talked about divorce. Let's talk a little bit about other aspects of family court. So you touched on adoptions, which is a happy moment for us, right?
Uncontested adoptions are great. And we, unfortunately, the last few months, we've had to do the adoption dockets by Zoom, and it's not the same thing. But typically, when we're not in the throes of a pandemic, we have each case that comes in the courtroom individually, and that is a happy day for me. It's the seeing these children and getting to be a part of their lives and talking to them and meeting them is important to me. I love kids. My wife may tell you I've got a lot of kid in me now, but it's just a great day to be able to spend time with the children and their family. And I will tell you, I know that I've talked about with Lisa Collins and Jenny Hall and a few of the other Wendy Rutherford, a few of the other lawyers that work in adoptions is having an adoption day. We were going to have one this past year, but COVID creeped in and prevented us from having it. But have an adoption day during Adoption Awareness Month, and I'm excited about doing that at some point in the future. But uncontested adoptions are by far the cases that I enjoy the most. Contested adoptions, termination of parental rights, they're not enjoyable.
Now, let's talk about termination of parental rights, dependent and neglect actions. What is that?
Well, dependent neglect is a statutory basis for dealing with parents that have neglected or abused children, and it's a very, in my opinion, very well written statute, and hasn't been significantly changed over the last 30 years. Juvenile court has original and exclusive jurisdiction on dependent neglect actions, which means it's got to be heard first in juvenile court. Now, traditionally, the two family law courts have gotten the appeals from juvenile court on the dependent neglect cases. Dependent neglect cases are totally different than say a post-divorce modification of custody. You got a higher standard of proof, clear and convincing evidence. You've got, you're going to have more lawyers. You're going to have the child is going to have a lawyer, guardian ad litem, may in rare circumstances actually have an attorney ad litem. These can be complicated cases, and they generally take more time to hear because of the number of lawyers in the case. In circuit court, we only have appellate jurisdiction over those cases. And at this point in time, based on agreement from about a year ago, any dependent neglect that arises out of a divorce case that is later appealed to circuit court goes back to that divorce judge. But any dependent neglect case that is appealed that is unrelated to a pending divorce case or past divorce case, it goes to one of the other civil circuit judges, with the exception of Judge McClendon and Judge Kennedy. So, we're having to do that from a caseload balancing standpoint. It's hard to carve out a class of cases and spread those around among multiple judges. But we felt like we had to do something, and that's what we decided to do on those.
Is it possible to have a dependent and neglect case pending at the same time that a divorce case is pending?
Oh, yeah, yeah. We have it. There have been cases where dependent neglect cases have been filed in juvenile court, either by the Department of Children's Services or by private lawyers, while we've been hearing the divorce case that is involving custody. And I lose jurisdiction immediately over the issue of the children, because that goes to juvenile court under their original and exclusive jurisdiction.
And are there any circumstances by which it comes back to you? For example, if it's
Oh, yeah.
dismissed in juvenile court, will the jurisdiction come back to you?
Yeah, if the case is dismissed down there, it will come back to me as part of the divorce. If the case is not dismissed and there's been a finding by dependent neglect, then it, under the new rule, it will come back to me as a dependent neglect case. And I have to try that separately from the divorce case. I have to adjudicate that. And the reason is the significantly higher burden of proof in the statutes that address dependent neglect cases.
And do you suspend or put a pause button on the divorce case while a dependent and neglect case is going on?
I do, because issues on children can affect so many things. I'm not going to grant the divorce. Judge Robinson and I are both sticklers to not to grant the divorce until the whole case is ready to be completed. And this is tough, but you don't know what the party's finances are going to be necessarily. How do you divide property when you don't know what the monetary accounts are going to be? These parties are eating up thousands of dollars in fees every month. I can't address child support. Alimony can, you've got to consider child support and an alimony award. There's so many factors that are so many things that can be affected by the children that I've just taken the position, we'll just wait till they're through with the dependent neglect and we'll see where we are and go on from there.
Okay. So we've talked about divorces, contested and uncontested. We've talked about termination, dependent neglect, adoption cases. Let's talk about post-divorce matters. What type of matters are post-divorce matters?
Well, generally, they are modification or enforcement of child support, modification or enforcement of alimony, modification of or enforcement of the parenting plan. And it may be that the parents in regards to the parenting plan, it may be that the parents aren't getting along at this point, and maybe one is challenging joint decision-making authority. It could be that one parent is now asking to be designated the primary residential parent, or it could be that one parent just wants to modify the schedule. Those are cases that can get complex at times, but we actually do a lot of those, and you'd kind of be surprised, but a lot of those cases actually settle due to my top-notch A1 special master.
That would be me, because I failed to introduce myself at the beginning. I'm Stephanie Williams, and I'm the special master for Judge Philip Smith in the Fourth Circuit Court. So, and that takes me to my next question that we got in advance. And one question that someone asked is, how do you try to resolve disputes amicably? Is that really the court's job? Or if it is, what do we do to try to do that?
Well, first of all, I do think it's the court's responsibility to resolve the dispute. Generally, when the court gets to the point where I have to make a decision, it's probably not going to be amicable in the sense that both parties are going to walk away happy. that's difficult to do. However, I do think that mediation has been great to settle cases in a more through a more amicable process. And mediation, is great. I think people litigants sometimes put a little more faith in mediation than they should. At the same time, mediation is a way for parties to settle cases in a way that they may not be completely happy with, but that both sides can live with. Again, I don't know what happens in mediation, except to the extent that either it's settled or it didn't settle. They have an opportunity to work with the mediator, kind of chisel out an agreement that is really specific and really addresses their concerns, and maybe meets with the approval of both parents. When it gets to the judge is going to get a snapshot in their life. In a 1 or 2 or 4-day trial, I just get a snapshot into their life. And I will do the best I can to make a fair decision. At the same time, they may not feel like my decision is fair. My spouse got more of this, and maybe I should have gotten, I feel like I should have gotten more. Well, I try to always explain why I do something. Oftentimes, or I hope it's not oftentimes, sometimes it's erroneous. But I try to explain why I'm doing what I do. But I really encourage litigants to listen to their lawyers on mediation. Go in with a plan and be ready to accept something that you may not be completely happy with, but you can live with. Don't go in with the attitude, we're going to go in and do this 2 hours and then we're going to set this for trial. Because again, you're not going to get the work with a scalpel that you would in mediation. You're going to get more of a meat cleaver from any court, because we can't do what the parties can do themselves.
Yeah, I always try to emphasize to people, like, you still hold, for as long as you're able to come up with your own agreement, like, you still hold the answer to your issue. You still have the power. You still have the ability to have an outcome that you have a stake in, versus you lose that power going to trial, right? You can only testify. You can only give the court information in accordance with the rules of evidence. So everything you want to say and everything you want to get into court may or may not get into court. And then at that point, you just dump all the information on the judge and he makes a decision and you're powerless. And so I think it is so important, in particular when children are involved, or we're talking about monetary matters, talking about alimony, like that people do everything they can to preserve their power and to come up with their own decision. Because they're the ones that have to live this out. Once the court's done with it, the court's done with it. They're the ones that have to live it out. So
yeah, those pesky rules of evidence and rules of procedure, they just get in the way of everything, don't they?
They do. People think they're just going to get in all this stuff. They'll be in a judicial settlement conference. I'm like, no, that's not happening. Your trial is next week, and I haven't seen, that you followed these steps to properly get it in. And so, yeah, they can definitely cause some issues for people. So you talked about post-divorce matters, and you were saying the enforcement of child support, the enforcement of alimony, the enforcement of parenting plans. What does that mean? What does that look like when someone is saying, I'm not getting my support, or somebody's not following a parenting plan? What is an enforcement action?
An enforcement action generally is a contempt. It could be other things, potentially a wage assignment for the non-payment of child support, things of that nature. But generally, it is a petition for civil or criminal contempt. And we see a lot of petitions for contempt. See a lot of, in the enforcement of child support and alimony, see a lot of petitions for criminal contempt. And if the proof is there, which is guilt beyond a reasonable doubt, then I'm going to enforce my orders. I try to be judicious in the enforcement of my orders, particularly in the use of incarceration. But sometimes we have to make tough decisions that we don't particularly like to make in order to enforce our orders. But really, if you think about it, contempt is the only way any court has to enforce its orders, not just family courts, but any court.
So going back to some things as it relates to the public and attorneys being informed, how can people find out about the court's closures? Like this week, we've been closed. How can people find out information about that? How can people find out information about upcoming dockets and how to participate? If it's going to be by phone, telephone conference, if it's going to be by Zoom, and the information to participate, what mechanisms do we have where we're providing that information to people?
Well, right now, let me kind of break that down. First of all, in the weather situation, I know lawyers are probably thinking, Judge Smith and Judge Robinson are making decisions on whether to have court or not. Now, we're actually following the mayor's lead, all of the trial courts, all 18 of us. And the mayor has been closing has closed the metro system down, except for essential departments. And so, I put on Facebook to let lawyers know that Third and Fourth Circuit are going to be closed. Actually, all of the state trial courts are closed, but I've just referenced Third and Fourth Circuit. You need to always check the local channels on closings and things of that nature. Generally, it's the trial judges that we all 18 kind of give their input to our court administrator, Tim Townsend, and he and the presiding judge, Judge Joe Binkley Jr., get together and make the decision. This week, the decision's been made for us, which we're fine with. But you could always look on the Metro government news page under the mayor's office. It will be there. It will be on the network channels, local channels. And we also try to get it out on the Facebook page. Now, in regard to, I forgot, I'm sorry, but I forgot what the second part was. I didn't write it down.
Well, part of my problem is I asked like 10 questions in one. So
no, I got it. I remember it now. In regard to the dockets, Ricky Rooker, who is just a great clerk, he is posting those every week. We, you and I get together, obviously, on the motion docket. We post the times when the motions are going to be heard. We're using the staggered docket concept right now. And, we post on there the Zoom link and try to make it easy. Or if it's going to be heard by Bridgeline, we post that information also. Lawyers generally know this, pro se's don't, but we're trying to get the word out through Ricky Rooker. And you can always call the court and you can find out if your motion is on or if it's not on. We don't want you to make a trip to the courthouse unnecessarily. So those are things that we can do. Like I say, we're posting it every week. I am hoping we get to do a motion docket Friday. I don't know what the situation will be on that, but that avoids doing double dockets next Friday. But I hope that answers your question.
I think it does. So I just want to say thank you for this evening. I want to talk a little bit about, before we go, we're going to do this next month on the third Wednesday, which I don't have that date in front of me right now at 6 o'clock. What will your topic be at that time?
We'll be talking about divorces. We'll be talking about, uncontested divorces in more detail. We're going to talk a lot about the pro se divorces, pro se with children, pro se divorces without children, how we're dealing with those, how you can make it easier for yourself. If you are a pro se litigant, what steps you need to take, where you can go to get information, things of that nature. Now, I will say, unfortunately for the lawyers, this is not a CLE. I know everybody probably has sat here and listened to me for an hour and not getting any credit for it. But again, this is just an overview tonight. We're going to be getting into specific topics. Again, if you want to join, you're more than welcome to. But I would ask that you include your clients, and we'd love to see them. We'd love to let them hear what we have to say and explain what we do and why we do it.
And is it
Thank
possible
you all for coming out.
Is it possible that maybe next month you can bust a rhyme for us? I know you've got some raps that the bar is not really informed about, or the public in general. I think that could go viral.
I will actually rap a little bit of my favorite rap, DJ Hollywood, Shock the House.
All right. So we're going to get a teaser of that next month.
You will. Yes, you will. You will hear it next month.
We're going to hear it next month. Okay.
Part of it. So, yeah, I'm not comfortable doing it all.
We can just open up with that, right? That can just be the opening.
We could. Yeah.
I'm so looking forward to it. Okay. Thank you all for being here tonight. We look forward to seeing you and your clients next month, and have a good evening. Stay safe and stay warm. Good night, Judge.
Good night.